But of course, before giving the floor to my members, to members of my delegation, I would like to answer some of the questions which I see that it'd be appropriate if I have the answer for it. First of all, there were several remarks concerning the drafting of the report. Of course, we welcome these comments that we had, and we certainly will take those remarks into our consideration, as well as we will ensure drafting the future report in accordance with the guideline of reporting the treaty bodies. I would also like to add that, or answer the question that if the civil society were invited to this report and drafting the report. I would just like to add that the report was submitted to several civil societies, namely the Kuwaiti Lawyers Association, the Human Rights Association, and the Kuwait Association for Fundamental Principles of Human Rights. There was also another question concerning that we have three bodies or three committees for human rights and how we cooperate with them, and this doesn't make confusions. In my statement, when I mentioned those committees, I went into a sequence. I mean, what we started, how we started. So we started first with the Committee for Ministry of Interior. Then it was the Standing Committee where it was under the aspects of Minister of Justice. So the first one was cancelled afterwards. So it was the one which was at by 2008. But of course, it was not under Paris Principles, and this is why when we came to the UPR, we, of course, said that we were going to have a national committee, independent, with the Paris Principles. Of course, as I mentioned in the also open statement, that the National Human Rights Institution has been taking a big steps forward, and we had a lot of meetings with the High Commissioner's office, and I think we are in the final stages to come out with the principles of this institution, which we look forward, of course, we look forward to be an A grade or A class institution. Then, with regards to the Chairman Rapporteur's question mentioned regarding the dissolution of the National Assembly in 2011 November. This act was done within the rules of the Constitution. And then, according to the Constitution, within 60 days we have to have the election. And this is why on the 2nd of February we had the election. And 3 days ago we had the Assembly held its first session. Then there was a question also regarding the capital punishment. We have 36 death penalty sentences, but since 2007, none of them were executed. Of course, if we look into those cases, we see that we have 5 women and we have 31 men. For the women, they are all death issues, killing, I mean, one of them even a Kuwaiti, one in the Ethiopian, and one from Philippines and Sri Lanka. And for the men, we have Kuwaitis, we have Pakistanis, Iranian, Egyptian, and Indian, and also one Iraqi. Even in the Kuwaitis, we have one of the ruling family members. And of course, I will give now the floor to Mr. Ja'far, the attorney, to give more details regarding the capital punishment and other issues which concerning trafficking and other matters. Thank you.
Bismillah.
In the name of God, the Merciful, the Compassionate. Thank you, sir, and distinguished members of the committee. And I would like to address my thanks to the chair of our delegation. To begin with, I shall address the bill on combating the trafficking of persons, and we received a question in this respect yesterday. The state of Kuwait was keen to adhere to the 2 protocols associated with the United Nations Convention on the Combat of Organized Crime, on the suppression, the prohibition, and the punishment for the crime of trafficking in persons, especially women and children, and the combat of the smuggling of migrants by land, by air, and by sea, and those have been ratified by Law Number 5 for 2006 that was promulgated on the 27th of March 2006. Hence, the Convention and the Protocol on the prohibition and the punishment for the crime of trafficking in persons has become an integral part of our legislative system in the state of Kuwait. It is worth mentioning that the Kuwaiti legislator has allocated a number of frameworks for protection as part of the Penal Code of Kuwait number 16 for 1960 and its amendments in order to safeguard the combat of the trafficking of persons and the protection of those who would fall victim to such trafficking during their presence on the soil of the state of Kuwait. The Penal Code has got many texts and provisions that would certainly provide a protective umbrella in penal terms for the rights and the freedoms of labor and migrant labor. Amongst these is the allocation of severe penalties for crimes in this respect, like crimes of murder, violence, abduction, sequestration, and trafficking in slaves, as well as providing for compensation when the victims claim compensation. Article 49 of Law 31 of 1970 amends the penal code and criminalizes all forms of forced labor and the exploitation of persons or the withholding of their wages and salaries without justification. This article stipulates that shall be punished by an imprisonment of a period that does not exceed 3 years and a fine that does not exceed 225 dinars, that is equivalent to $1,000, or one of those 2 penalties. Those should be applied to any official worker, employer, or worker who has utilized workers in the work of the state or any of its organs in a coercive or in a forced manner, or who has withheld part or all of their wages or salaries. On the question of combating trafficking in persons and slavery, the Penal Code of Kuwait in Article 185 prohibits the entrance or the bringing in or the taking out of a human being to Kuwait or from Kuwait to use those people as slaves, as well as anybody who would buy or would offer for sale a human being as a slave. And it added also a number of fines that does not exceed 5 years and a fine that does not exceed $2,000 against anyone who would engage in any such acts. In practical terms, inside the state of Kuwait, there is no trafficking in slaves in the internationally defined definition, which is the purchase or the selling of a human being with the purpose of enslaving them. But there are individual cases where there is exploitation of the services offered by some of the workers in order to make financial gains. Also, the Penal Code criminalizes many of the acts associated with wantonness and prostitution, as well as the incitement to engage in such acts. And it provides for a year's prison sentence, and this is compounded if the person is less than 18 years of age. And it does not exceed 5 years if the criminal compels a minor or deludes a minor into engaging in such acts of prostitution, and it reaches 7 years if the victim is less than 13 years. Any person who withholds a person entirely and utilizes the benefits of the prostitution of others, be that with consent, free of charge, or as a racket or protection money, and also all persons that manage or that run a prostitution, a place set for prostitution, would be punished similarly. Also, crimes of prostitution during 2010 have been 210 in number, and the accused have been condemned in 126 of the cases, and there were 84 acquittals. Also, Law Number 3 of 1982 on minors who are children below 18 years of age. In Article 21, the law stipulates the punishment of any person who would cause cause the delinquency of a minor or engage any of the minors in acts like wantonness or prostitution or employment that is not an honorable source of income. And the punishment had been stated at 3 months without prejudice to any other punishments that could be applied by the Penal Code. And the imprisonment sentence does not exceed 3 years if the criminal has engaged in the prostitution of people who were in his care or under his tutelage. Also, it is worth mentioning that the Ministry of Justice has prepared a draft law on the trafficking in persons and the smuggling of migrant workers, and this was submitted to the Cabinet for adoption, and the Cabinet in turn has referred that to the Legislative Committee of the Majlis al-Ummah, the People's Assembly, and which was adopted unanimously, and currently it is being ratified by the Assembly, and it will then be ratified by His Highness the Emir of Kuwait according to the constitutional provisions, of Article 79, which stipulates that there would be no law unless it has been adopted by the Assembly and ratified by the EPIR. In this respect, the law has organized a number of elements, including the definition of the crime of trafficking in persons and the smuggling of migrants, and that according to the terms of international conventions, and the determination of very harsh penalties and punishments that could reach life imprisonments for the perpetrators of such crimes, as well as the confiscation of the tools that have been used to commit those crimes. In addition to that, the draft law has enumerated many of the safeguards and the special services reserved for the victims of trafficking in persons and the smuggled migrants, like medical and social welfare, or their shelter in one of the shelters allocated by the state for this purpose. On the protection of migrant workers against all forms of discrimination, Law number 40 of 1992 was promulgated on the organization of the work of employment agencies for domestic workers and those who are in a similar situation. And the first article has prohibited the engagement in activities of providing employment without obtaining a prior permit or license from the Ministry of the Interior. Here, the legislator was very keen to make sure that the protection would not be confined to domestic workers alone, but also extended the protection to cover those who are in a similar situation, like those who are associated with the person of the servant, like, for example, a driver who would not be a domestic worker but who would be employed by an employer, and that in order to safeguard the humanity of the worker so that the worker would not appear as a commodity, and it is not possible for anyone to obtain any sums of money from the worker in exchange for finding a job for them. The state of Kuwait is keen on providing health services to migrant workers, and hence Law number 1 of 1999 was promulgated to provide health insurance for foreigners in exchange for symbolic fees against providing them health services, and it is not possible for people to have a residency permit before having their medical insurance or insurance guarantees. And the legislator in this was making sure that all those who work in Kuwait have got health insurance and basic health services. On the protection of domestic workers, Law 617 of 1992 was promulgated for the purpose of organizing the laws and the procedures for obtaining the permits for employment agencies. It is worth mentioning that the right to litigation is provided for everybody. It is possible for any domestic worker or any worker in general to address himself or herself to the law to ask for redress of rights that he had been deprived of. In addition to that, he or she could receive compensation and could have their rights restored. There is another issue that we received a question on the implementation of the Islamic Sharia in Kuwaiti courts, and to what extent is the Islamic Sharia applied to those who do not belong to the four Sunni jurisdictional schools, like those who are the followers of the Jafari jurisdiction school, and what also is the situation of non-Muslims. The laws in Kuwait are positive laws, and we take that from the principles of Islamic Sharia. In particular, this applies to cases of personal statute or personal status, like marriage, divorce, and alimony, as well as other issues related to the family. Article 346 of the personal status law stipulates that this law shall be applied, that is to say, the personal status law shall be applied to those who were covered by the jurisdictional school of the Imam Malik. Otherwise, they would have their own laws applied to them. This means that those who adhere to the Malik school would have the law applied to them for personal status, and others who are not who do not adhere to this school would have their own laws applied to them, and the courts in Kuwait apply the personal status laws if the parties to the dispute are foreigners and have asked for the application of the laws that concern them or that they wish. In this case, it is necessary to provide the judge with a ratified copy of this law, and here the judge decides according to this law.
There are special rules for the Jafari, which is the Shiite. There are cases that are being considered in this court, whether from the Kuwaitis or the foreigners. Kuwaiti courts specified special courts for personal disputes for non-Muslims, and the judge rules according to their religion or their specific law. Now I should like to, this was regarding the Islamic Sharia in Kuwaiti court. As for the question on the capital punishment, here we should like to speak about certain legal aspects. For example, this punishment is not rendered by the court unless there are the circumstances that justify that, such as premeditation and ambush. For example, when there is a premeditation, there is time to plan and to meditate and to think. The person takes his or her time in order to plan for the crime, and then one might await in an ambush for the victim in order to carry out their crime suddenly. And this was contained in Article 151 of the Penal Code. Every perpetrator or suspect is given full legal safeguards to have a fair trial without any distinction between any suspect or another, and not only for capital punishment crimes. Article 1 of the Code of Penal Procedures says that no punishment can be rendered unless a court has been held according to the rules and regulations of this law. Every suspect has the right to attend all the trial sessions and to be accompanied by a legal counsel. When the suspect has not the wherewithal to take a special legal counsel, Article 120 of the same law, this article of that law, Article 120, obliges the court to assign a lawyer to defend the suspect. The suspect will not be asked to take the oath before he gives his statement before the court, in order for him to be able to deny his previous admission and not to extract a confession from him under duress or during torture. If that happens, that means that his statements will be considered null and void, and those who force a suspect to do that will be punished severely. There are other and many safeguards that are stipulated in the Penal Code and the Code for Penal Procedures. For the same capital punishment, Article 211 of the law stipulates that any sentence rendered by the Court of First Instance, which is formed of 3 judges, which if it renders a sentence for capital punishment, this same court refers it by itself to a court of appeal, which is formed of 3 advisors or consultants, legal consultants. After that, the Court of Appeal can annul the capital punishment and can give a lesser sentence or even find the suspect non-guilty. If it confirms the sentence, the Court of Appeal, even if the suspect does not take recourse, it itself transfers it to the Court of Cassation, which is formed of 7 judges, and this court reviews and considers the case from the beginning, and it can either affirm or annul the sentence. If the sentence has been confirmed, it cannot be executed unless the emir ratifies it. So the suspect will remain in prison until the emir can either confirm it, commute it, or pardon. And if the sentenced person is a woman and it appears that she is pregnant, and when she when the baby is born, instead of giving her a capital punishment, the sentence is commuted to life sentence, and that's in operation of Articles 217 and 218 of the Penal Procedures Code. Thank you, sir.
بسم الله الرحمن الرحيم. شكرا.
The compassionate. Thank you, Mr. Chairman. I should like to thank the head of the Kuwaiti delegation. Yesterday, there were many questions and queries, some of which were about the legal protection provided to foreign workers in Kuwait. Some of the questions were related to how comprehensive is the labor law for the workers in the private sector, and does this law apply to this category of workers? What is the minimum rate of remuneration for foreign workers, and what is the status of those who employ children, such as what was called the jockeys for camels? Before I respond to these questions, I should like to shed light on specific points. For example, more than one expert in your esteemed committee used the term migrant workers. And here, Mr. Chairperson, and as we had done before on previous occasions, I should like to reaffirm and to reiterate that the concept of migrant workers does not apply to the state of Kuwait. In Kuwait, there is no migrant worker per se. The workers who are in Kuwait are temporary workers, and they come for a specific task. So instead of saying migrant workers or immigrant workers, says the speaker, we have what we call contractual workers. All those who work in Kuwait, whether in the public or private sectors, or domestic workers, all of these are temporary workers, and as soon as their contract comes to an end, this category of people goes back to their countries. Therefore, we don't have migrant workers. As for the remaining questions on the protection of workers, what is the minimum wages, the employment of children as jockeys, and labor agencies? As all these matters have been regulated by the labor law regarding private sectors, law number 6 of 2010, where it amended a lot of the regulations that were contained in law 38 of 1964. Mr. Chairman, it is noteworthy to say that the labor work in the private sector 6/2010, when it was formulated, it was after consultation with the ILO and with the experts of the ILO, the Ministry of Social Work and Labor, and the Parliament of Kuwait, Majlis al-Umma. Both have worked to make the provisions of this law in line and in conformity with the international labor conventions to which Kuwait has adhered and ratified. Now I should like to talk about the legal protection provided by this law. This protection can be summarized in various stages. Firstly, in accordance to Article 10 of Law 6/2010, and in a nutshell, in order to save time, I should like to just mention the article. Article 10 of this law prohibits that an employer employs or imports workers if it is proven that they do not really need this person. And this act has been criminalized. Article 28 of the same law, the legislator prohibited that the employer might reduce the wages, and any action of this form is null and void. Article 6 of the same law, the legislator made that the provision of this law are the base minimum, lesser than which would be criminal, and in fact it had allowed that more privileges can be added to this minimum wage in accordance with the law regulations of the employer. Article 115 of the same law, the legislator made null and void any settlement or any conciliation that might be signed by the worker regarding his rights, which is in contradiction with the texts of the law. And amongst other forms of protection that have been awarded to the worker by the legislator, and I mean by here the private sector worker, who are at least 1/3 of the population of Kuwait. More than 1 million persons work in the private sector out of the total number of the population of Kuwait, which is more than 3 million. And here I should like to digress to respond to maybe some kind of confusion that was in a question by one of the experts. He asked, is the 3 million contains the Kuwaitis and non-Kuwaitis? Yes, the number of the population of Kuwait is 3 million and some, but the Kuwaitis are 1,100,000 maybe. The rest of those are foreigners. 75% of them are those who are working in all sectors of the country. Then again, Mr. Chairman, I should like to say that part of the protection provided by the law to the private sector workers is the establishment of an organ for the inspection on labor. Here we have inspectors and workers who have legal powers to go and inspect labor places and to refer any anomaly to the competent authorities. There are even more safeguards and protection provided by the law. The legislator made it compulsory on an employer by virtue of Article 57 that the employer must open an account for the worker in the banks, and that the employer should transfer the salary of the worker to this accredited bank and to provide the Ministry of Social Affairs and Labor a statement that shows that the employer is truly transferring the salaries of his workers to these banks. This is part of the protection provided by the law. And I should like to say that there are other divisions that are present in the 6 governorates of Kuwait, which receive complaints from workers regarding their financial privileges or any other labor dispute. And should there be a dispute and the settlement of dispute would not be possible in a conciliatory fashion, it is referred to the court. And since 2010 until now, the number of the cases that have been referred from the Ministry of Social Affairs and Labor to the courts, around 1,800 cases. 30% of these cases have been reviewed and sentenced, and the rest is still under consideration. Mr. Chairman, I should like here to move to another aspect to respond to other questions that have been asked regarding the minimum wages. Law number 6, 2010 again. And in contradiction with the previous law, formulated a new text which binds the Minister of Social Affairs to establish a law that would decide the minimum wage, and that this minimum wage should be reviewed once every 5 years, taking into consideration inflation and other economic factors. Decision has been taken to make 60 KD, that is $200, as the minimum wage. Some might find that this amount is very little, $200. But if we really debate the matter and reflect on it, we will find that this $200 or 60 KDs, this is the minimum wage of cleaning employers and domestic workers. And in accordance of a decree by the Cabinet that was issued 2010, this amount is considered the net wage that the employer will give to the worker. Added to that, the employer would have to bear the living expenses of the worker to provide housing, to provide transportation, to provide food and clothing. 60 KDs or 200 USD is just what you might call a pocket money for this worker, whether it's an employer in cleaning employment or a domestic worker. As for the question on children jockeys, whether camels or horses, I should like to affirm here that yes, this phenomenon used to exist in previous years, but since 7 years the situation has changed completely. The Ministry of Social Affairs issued a decree that prohibits the use of children in these professions, and instead of them we are using now robots. The robots are being used since 2004, and until now no child has been employed as a jockey. As for the employment agencies, and this is probably the last question that I remember amongst the questions that were asked yesterday, yes, I agree. I beg your pardon. Before going to the employment agencies, I should like to talk about the system of the sponsor, which was asked by many experts yesterday. Yes, Mr. Chairman, the system of sponsor is a system that is really imbued with many negativities or can be improved. However, this system is not really deeply rooted in our legal system. This system of a sponsor has no presence in our legal body, not even in the labor law, the current one, nor the previous one, nor in any legislation. You will not even find the terminology sponsor. But there were some decisions taken by ministries that does not allow a worker to move from the employment of one person to another unless the first employer approves. And this decision was taken in order to take into consideration the situation in the market and to bring about a balance between the relationship between the worker and the employer. Of course, we see the negative aspects and the flaws of this system. And this is how this system came about. However, in 2009, the Minister of Social Affairs issued a law that allows the transfer of the work license from one person to another, from one employer to another, without the approval of the first employer, so long as the worker has been in the employ of the first employer for 3 years. And the Ministry of Social Affairs will itself transfer the permission to work as long as the 3 years have passed, and as if it ascertains to itself that the employer is being difficult and is holding the worker without justification. When that happens, the ministry, regarding all laws, once again, for any matters that come about, we are in consultation with the ILO and the experts in order to find a replacement for this system of sponsor to have a better system. Again, Law 6 of 2010. And in order, because we want to eliminate the system of sponsor, we have Article 9. Article 9 established a public organ that will oversee the affairs of the workers, that looks after the employment of workers in the private sector. The ministry has